is now in session.
Please be seated. Thank you. We're here today in 1CA CV140539, Man versus Hammond. As you may notice, Judge Thompson was unable to be with us today. He was on his way back to Arizona from Colorado, but his plane would not take off, so he won't be here, but he will participate in the case, so he'll be part of our decision-making process. Each side will have 20 minutes for argument, and appellant, you may reserve any amount of time you want for rebuttal, but it's your responsibility to keep track of that yourself. We have conference the case. We're familiar with the record and the arguments. So when you begin your argument, just launch right in to what you want us to know. Because we are recording this argument both in audio and video, please identify yourself and your client when you begin. So please begin, counsel.
Judge Howe, Judge Winthrop, may it please the court. My name is Alex Mann. I am the plaintiff and the appellant in this case. I hope you'll excuse me. I don't argue many appeals, so you'll have to excuse my initial stage fright. I would like to make one initial point, and that goes to the supplemental citation offered by the defendant. I will refer to the defendant and Osborne Maladon, maybe even O&M, as I've come to call them in the briefings. The first thing I would note is that the Supreme Court's reversal of Robertson v. Alling, the 2005 case, really doesn't apply in this particular case. That case went to the issue of apparent authority and the retention of apparent authority and the survivability of the proposition of apparent authority. The position here and the plaintiff's position is that the apparent authority was revoked when the plaintiff, defendant, the counter-defendant in that case, refused to agree to the settlement agreement that had been negotiated by his attorney. Simply said, not going to do it. It's in the record. It is in those materials that were presented by the defendant that were attached, and that was the record in the bankruptcy court regarding the then defendants, the Bennett defendants. So having revoked, expressly revoked, the apparent authority, and then agreeing only to the dismissal of the civil forfeiture action. Two actions under that same case number, a civil forfeiture action and then the counterclaim. Plaintiff only agreed to dismiss with prejudice the civil forfeiture action to which he was not a party. He did not stipulate to dismiss the counterclaim action to which he was a party. Similarly, he did not stipulate to the absorption of the attorney's fees and costs that was part of that stipulation, stipulated only to the dismissal with prejudice of the civil forfeiture action.
How was that matter presented to the bankruptcy court?
That apparently was presented to the bankruptcy court by my attorney because the plaintiff's attorney instructed his attorney to revoke any offer settlement that had been engaged in, and it was presented in the bankruptcy court's record as Mann, Detective Mann, I was an assistant attorney general at the time, but he called me Detective Mann, has essentially said he's not going to sign the settlement agreement and not participate in the settlement agreement. The settlement agreement was modified. In that settlement agreement, Mann was left out as a settling party. The next time Mann shows up is at a stipulation at a later time, and you had various parties. And those parties stipulated to different things. They did not stipulate to everything.
Well, so I'm just trying to understand at the bankruptcy, we'll get to the Superior Court in a minute, but at the bankruptcy court level, so what was in front of the bankruptcy court judge? Was approval of what?
The defendant in that case, counterclaimant, had between the time that the civil forfeiture action was initiated against him and the time he initiated the counterclaim against the counter defendants had gone into bankruptcy. And as a consequence, his cause of action became part of the bankruptcy estate. And the bankruptcy trustee then, as the owner of the estate, the owner of the claim, engaged in negotiations with a party to settle it. That's how it got to the bankruptcy court.
And the bankruptcy court then approved a settlement which included dismissal or authorization to dismiss all claims in the Superior Court.
Well, it ultimately wound up arguably dismissing all claims, but it was specific that Mann was not part of the settlement agreement, and therefore Mann was not a party to that agreed to dismiss the counterclaim action in the Superior Court.
All right, so then the matter moves to the venue of the Superior Court. There's a stipulation to dismiss all claims, each party to bear their own costs and fees, with a fully executed stipulation signed by your counsel.
There were essentially three stipulations. One stipulation was to dismiss with prejudice the civil forfeiture action. Then a stipulation to dismiss the counterclaim action.
Right.
And then a cleanup stipulation to that all the parties would absorb their own attorney's fees and costs.
And as part of the dismissal of the forfeiture action, and there was payment of money by the state?
Now, it was paid by the Maricopa County Attorney's Office.
All right,
and I think there's a distinction here because I believe it was paid for, I was not there, but I believe it was paid for out of RICO funds. I don't know the source of the funds, but essentially it was the Maricopa County Attorney who made the settlement of the civil forfeiture action that they were prosecuting. I was not part of the civil forfeiture action, nor was my employer at the beginning, the Attorney General's office.
Okay. Were you named in the release that accompanied that payment?
I never saw a release, so to my knowledge, the answer is no.
All right. But I guess the indisputable fact is there was a stipulation for dismissal signed purportedly on your behalf by your counsel.
Yes, but only to the civil forfeiture action, not to anything else. I had revoked all authority.
I know, but did the document say that?
I don't recall specifically from looking at the document. I can dig it up. It appears to me that there was no differentiation between the three. But I think an internal look at that document logically says that was the case, simply because, for example, the Maricopa County Attorney's Office was not a counter-defendant, and yet it signed off. So if it's not a counter-defendant in the counterclaim, what's the legal effect of a non-party signing off on the counterclaim? Same with me. There was no legal effect to me signing off on the civil forfeiture action because I was not a party. But it was specific in the settlement agreement that I was not a party to it, and the documents that led up to that specifically stated I was not a signatory to the settlement agreement that was the underpinning of the stipulation.
But there were counterclaims against you that, and correct me if I misunderstand the record, that were dismissed as part of the agreement in Superior Court.
Well, that's an argument to be had too. The issue is was it dismissed against me? I think that there's a possibility that indeed the counterclaim, or at least because I was a necessary party to dismissal of the counterclaim, and I did not agree to dismiss the counterclaim, that ultimately the counterclaim was not dismissed as a result of that document. And later on, when the case was dismissed for lack of prosecution months later, that's when the case, the counterclaim as to me was dismissed. But my argument is the counterclaim was not dismissed by virtue of that stipulation, not by me, by the other parties perhaps, but expressly not by me. But I think a key point here is when you have a collision of facts like this, where the defense would have it that that stipulation did encompass me as far as stipulating to the dismissal of the counterclaim, I think that's a fact issue for the jury on exactly what the revocation included and was the apparent authority revoked, and if my attorney did not have the authorization to agree to me paying the or absorbing the attorney's fees and costs, then we go to Rule 80D. There has to be a writing to sort out what the authority was. The apparent authority had been revoked. What was the specific authority of my attorneys? My argument is that he was not authorized to sign that element of the stipulation that said I was going to absorb the attorney's fees and costs. Incidentally, there were no attorney's fees and costs were de minimis, but I didn't agree to absorb them. So ultimately, it's a fact issue to be determined by the jury as to the nature, level, and completeness of that revocation. And if that revocation was complete as to everything except the civil forfeiture action, then my attorney was not authorized to stipulate to that. And under 80D and under the Supreme Court decision, there had to be a writing that essentially rehabilitated my attorney's authority. There was no such writing. I certainly never wrote it. I never appeared in court, and I'm not aware that there was any writing between my attorney and any of the other parties' attorneys reestablishing his authority to stipulate to the dismissal or the absorption of those fees.
Okay, so whether the counterclaim was dismissed as part of the settlement, or whether it was subsequently dismissed for want of prosecution, the claim went away and there wasn't a ruling in your favor. Correct? So how can you?
I think there was a ruling in my favor. As far as the counterclaim was concerned, I never agreed to dismiss it. I never paid anything. I was not part of that $150,000.
So are you saying that a dismissal for failure to prosecute is a termination on the merits?
That's what the law says. Law says a failure to prosecute is deemed a determination on the merits for the defendant upon whom the prosecution terminated because of failure to prosecute. I have the citation in my materials that speaks exactly to that. And the other element of this is that under the factual circumstances, even if I had signed that agreement, and even if it was complete that I had stipulated to the dismissal of the counterclaim action, that is not absolute. There are certain circumstances where that can be a favorable determination. Many courts in Arizona, cited in the authorities, have said exactly that. You've got to go behind it. And where there's conflicting information, conflicting facts, then you have to present that to the jury. And it's ultimately a jury determination to make the decision on whether it was a favorable termination. And I would argue that the mere fact that it is part of the jury instruction for a wrongful institution of civil proceedings, that it's one of the elements that is left for the jury to determine, as a design factor in the law, it's anticipated that the jury will make the determination of whether it was terminated in the plaintiff in the WICP action's favor. To dismiss it at the trial court level certainly is not consistent with the law, and in a lot of cases it's even kind of more aggravated than that. For one thing, if reading the minute entry from the trial court, it is couched in terms of the word establish. He essentially ruled against me on the motion to dismiss because I failed to establish at the pleading level. Well, just going to Black's Law Dictionary and looking at what establish means, essentially it means to prove. Well, I'm not required to prove at the pleading level all my allegations. I wasn't required at the pleading level to prove that I had prevailed or had been a favorable termination to me. That's one of the issues that was going to go to the jury. If the defendants wanted to attack that, they should have then gone for motion for summary judgment. There we then could marshal our forces, present our competing facts, and the judge is either going to say there are no facts to support my position and therefore rule against me, or conversely say there are conflicting facts and it must go to the jury. So at the very least, that is the position to be had. But then looking at the minute entry itself, I think there's a whole series of flaws in that minute entry. For one of them, the law says that on a motion to dismiss that is not converted to a motion for summary judgment, that all the facts that I present in the pleadings, I have to be presumed as true, and any inferences have to be granted favorable consideration in my favor. The court, and I think the record is clear in the minute entry, didn't even address the facts that I had presented to the court in the pleading, in the complaint, and in the unexcluded extrinsic materials that the court said in his minute entry that he reviewed and considered. So what happens here is the law that says on a motion to dismiss level, all the inferences have to be taken in my favor, all the facts have to be viewed in the best light in my favor, essentially were ignored. And all the unsworn facts by defendant's counsel were taken as absolutely true. So I think that there's a flaw there also that has to be addressed by the court, and that was argued in the proceedings.
Mr. Mann, in light of the time that's left, did you want to talk at all about the intentional infliction of emotional distress claim?
Well, I think, Your Honor, I will admit that it is perhaps a unique approach, but it is my feeling that, and I don't think I used too strong a language when I said that government processes, i.e. court proceedings, are being corrupted. I think when an individual uses the good offices of government as the instrument of the infliction of intentional distress, that triggers a new requirement as far as what the statute of limitations is. And just like in a wrongful institution of civil proceedings, the statute of limitations does not accrue until the case is over. My argument is that when a party is using and corrupts governmental processes to inflict an injury, it's separate and distinct than a private injury, private processes, and that it's inconsistent with the Constitution that says that essentially relief for injuries will not be the plaintiff will not be deprived of those. So I think it's an argument that merits consideration by the court. I agree that it is unique. I agree that it's not within the mainstream. I do not see where it has been argued before, and I certainly think that it has traction. Key element being that when a government process is used as the injuring instrument, and it continues until the injuring instrument is no longer used, i.e. the case is dismissed, that's when the statute of limitations attaches, and any other interpretation is unconstitutional as applied in this case.
So even though the tortious conduct is complete at the time, your argument is that the effects of that tortious conduct toll the statute of limitations until the process is removed?
Every day that the case is not dismissed is another tortious insult. That's my point. Until the opposite party, the one who brought the lawsuit, dismisses it and stops the action and stops using the government process as an instrument of injury, until then, every single day that the case drags on in court is another injury to the defendant in such a case.
All right, it's a cumulative injury, but the conduct itself was complete months earlier.
I disagree with that. I think that once you set something in motion, and every single day the thing that you set in motion has an injurious impact, has a discrete injuring effect every single day until terminated, my argument is that is the way this thing should be, the law should be approached, and that's why it should be ruled unconstitutional in these specific circumstances. And I have 3 minutes left.
You may reserve the remainder for rebuttal if you wish.
Thank you, Your Honor. I will reserve.
Thank you. Counsel?
Good morning, Your Honor. Keith Beecham, representing the Osborne Maladon defendants. I think I'll touch briefly on the intentional infliction issue since that's fresh on our minds. I don't really have much to add to the brief. I really don't have anything to add to the brief. The one comment I would reiterate that is in our brief is putting aside the absence of any law to support this theory, putting aside our waiver argument, putting aside the notion that that theory would essentially gut having a statute of limitations at all. There's really no answer to the reality, the undisputed reality, that Osborne Maladon had no involvement in this case after December of 2010, which is well before the 2-year limitation period. So even if Mr. Mahon was correct that or could persuade you that the law should be changed and that his claim should not begin to accrue on the day the complaint was filed, which his own complaint says is the date he suffered injury, the involvement of Osborne Maladon in that tort ended well before the 2-year limitation period, even if you were to continue it beyond what the law currently allows now. There would be other defendants he could sue, and in fact did sue, the Carmichael and Powell defendants, who were defendants below in this case. He could sue them for that injury, but he couldn't possibly sue Osborne Maladon, even if you were to change the law. Let me turn now to really the questions that you were asking, Judge Winthrop, and the answers that were given. Let me try and clarify things a little bit first. The questions you asked about sort of underlying what happened here in terms of bankruptcy and whatnot, what was before the bankruptcy court to approve was the settlement itself, and the settlement is in Exhibit 3 to the motion to dismiss, which is part of our appendix. I apologize, I don't have the appendix page number here. That settlement walks through what the terms of the settlement are, and in paragraph 3 of that settlement, to touch on another issue that's been raised in the papers and again at argument today, the settlement was paid, the $150,000 was paid by the state of Arizona. It says so in the settlement agreement. The stipulation itself and the order itself actually say it will be paid by the settling parties, which would include everyone other than Mr. Mahon, but the settlement agreement itself makes clear it's the state of Arizona or its insurer. I don't think that particularly matters, but to the extent you think it does, it's his employer that's making the payment. The fundamental distinction we have here is Mr. Mahon saying that he didn't agree to dismiss the counterclaim, and the unfortunate reality for him is that the stipulation filed in Superior Court by his lawyer and the other lawyers does not say that. It actually says the opposite. I believe that's Exhibit 7 to the motion to dismiss, and in that it says that the counterclaim will be dismissed in its entirety with all of the parties, which includes Mr. Mahon, to bear their own attorney's fees and costs.
Well, he says he revoked his the authority that had been previously been given to his counsel, and so doesn't that at least create a question of fact?
No, it doesn't, for a couple of reasons. Whether the easiest issue, or the way to address it, is that whether his attorney had authority to sign that stipulation for him is irrelevant to the issue of favorable termination. This is not a case in which we're seeking specific performance of the settlement agreement. We weren't parties to it. The issue here is favorable termination, and whether his lawyer had authority or not, the reality is the outcome of that stipulation and the settlement, which is a matter of public record, was that there was not a favorable termination in his favor because the people whose counterclaim was dismissed, the counterclaim filed by my clients, received $150,000 in cash and benefits of $1.3 million in their bankruptcy, in addition to the attorney's fees and costs issue. So it's unlike Robertson in the sense that it's not a disputation in the very same case. This is an attack on a collateral order, which is actually a judgment in an underlying case that he was a party to, and he didn't raise any of these issues at the time, and he can't raise them now.
Well, Mr. Mann argues that that we should look at the dismissal that occurred later for failure to prosecute as being the critical deciding factor, and that was a resolution on the merits in his favor.
Well, if the stipulation that his attorney filed didn't say he was a party to it, that would be a good argument. But his attorney filed a stipulation that says that he was stipulating to the dismissal, and the attorney that filed that was his attorney. He had, if you look at the papers, he had a different attorney than all of the other defendants in Superior Court.
I guess I'm a little confused, though, because if the counterclaim had been dismissed as part of the settlement, and why is there a subsequent dismissal for lack of prosecution?
because there were numerous other parties in that lawsuit, and in fact, when you look at the dismissal in the Superior Court, it says dismissal of, and it says only, and it identifies who the parties, and I think it underlines in boldface the only part in the caption, because that case had numerous other parties to it, and those other parties are the folks to whom that subsequent failure to prosecute order applied to, not the folks who got dismissed earlier. That's why.
So Mr. Mann was not a part of that.
The subsequent dismissal for failure to prosecute had nothing to do with Mr. Mahon. He was only in the suit as a counterclaimant, and the claims against him in those counterclaims were dismissed pursuant to the stipulation and order in October.
Okay.
In the event that you are not persuaded by the first point I made, let me make a second one with respect to attorney authority. The Robertson case is not on all fours with this case, but it does, I think, provide you guidance, even if you didn't agree with me that the issue of favorable termination is unaffected here. It's undisputed that his attorney signed the stipulation. Mr. Mahon, in his motion for partial summary judgment below, expressly says, quote, plaintiff Mahon was a party to the stipulation. That's Appendix 203 at line 12. It's undisputed that under the terms of the stipulation, he gave up his right to fees and costs in the counterclaim and the defense of the counterclaim. And in Robertson, the Supreme Court considered a case where a party claimed that they were not bound by the terms of a settlement agreement because its counsel lacked authority. That case is different in a lot of ways than this one, but it does provide some guidance, because in Robertson, the Supreme Court's opinion was guided by its view that having fewer collateral attacks and having fewer challenges to settlement agreements was good public policy and was also consistent with Rule 80. And those same rules would apply here. And I think the argument that Mr. Mahon has made today underscores that, because what he is saying now is, well, wait, I was never party to, my lawyer didn't have authority to sign it, so this judgment, because it is a judgment that was entered back in October of 2012, is actually null and void as to me. And if, as of today, if the other claims had continued to be prosecuted and there hadn't been that order entered for failure to prosecute, well, presumably the Bennett's could still prosecute their counterclaim against him. It would really seek to undo any sort of finality, and it would put his employer, the state of Arizona, in a difficult position, maybe a more than difficult position, because if the counterclaim were to continue to be prosecuted against him, he presumably would ask the state of Arizona to indemnify him, as was happening in the case below, I'm sure. And presumably the state of Arizona could be on the hook for any attorney's fees that he incurred, and might be on the hook if the Bennett's were to proceed to judgment on their counterclaim. These are the kind of things that happen when you allow collateral attacks on judgments. And I think the Robertson case, even though the holding's not squarely on point here, I think the reasoning in that case is squarely on point as to why this should not be permitted.
And with respect to Mr. Mann's argument about Rule 80D, is it your position that the settlement agreement you referenced earlier satisfies that requirement?
I think my position would be that Rule 80D doesn't apply at all, because that, in Robertson, they said, and they concluded in Robertson that it didn't apply in that case in the Supreme Court. They said the issue of what the terms of the settlement are weren't in dispute. The issue is whether your lawyer had authority to enter into those terms. That's, I think, the same situation as we have here. I think the terms of what this agreement says aren't in dispute. The issue is whether his lawyer had authority. So I don't think Rule 80D squarely applies here. If Rule 80D did squarely apply here under Robertson, we clearly would prevail. They don't seem to think that you need to have a separate writing from a lawyer for every settlement agreement, and they shouldn't, because that would be a difficult way to practice law. So that you have apparent authority to do those things. So is
it your position that to the extent Mr. Mann has any remedy, it would lie against his former counsel?
Absolutely. Absolutely. Well, I'll leave it at that. I will just say absolutely. That is exactly where his remedy would lie. And that is a far better remedy if this is, in fact, if what he says is what really happened, that would be a far better remedy than unraveling a settlement and a judgment that were entered back in October of 2012. But I don't think it matters, because, as I said initially, the issue isn't can we specifically enforce the settlement, which was the issue in Robertson. The issue is, can he allege facts that would demonstrate, even giving him all reasonable inferences, that there was a termination in his favor? And here he cannot, because the circumstances of the termination of this settlement are undisputed. The Bennetts received $150,000 and 1.3 withdrawal of a $1.3 million claim. Those are not facts that suggest a favorable resolution in his favor below. And that's why the court was right to grant the motion to dismiss and not to permit a motion for leave to replead, because there are no facts that are going to change that those were the circumstances of that dismissal. If you have any questions for me on anything else, I'm happy to answer them, but that's primarily what I wanted to talk about.
Thank you, counsel.
Thank you.
Given a little bit of time, I'd like to just run through a few things quickly and then have any questions. First, Osborne Maldonado might have left before the dismissal passed to the subsequent attorneys, but they're the ones that launched it. And this is not one of those launch and leave weapons where you can simply launch it in the air and then decide to split. And then when the 2-year statute of limitation runs, you're clean despite the fact that you're the one that initiated the whole thing. Second thing is that I think that the revocation of apparent authority regarding the STIP was obvious to the Bennett party at that time, and once it has been revoked, there was nothing that was done to rehabilitate the revocation of the apparent authority, and my attorney did not have the apparent authority, therefore, to sign the stipulation as to anything other than the civil forfeiture action. As far as the favorable determination issue is concerned, I think the summary of facts indicates that there is a lot here in conflict as far as facts is concerned, and it is a jury decision as a result of that. I would offer that if the plaintiff can't challenge the stipulation, the defendant cannot use the stipulation against the plaintiff. In this case, I think that the plaintiff can challenge the stipulation for the purpose of showing that that element of the stipulation or any element of the stipulation other than to stipulate to dismiss with prejudice the CFA was not authorized. His attorney didn't have the authorization to stipulate to it, and the Bennett parties didn't. The minute entry regarding the failure to prosecute essentially was a catch-all, as I recall. They may have had an endorsement list that had specific names, but as I recall, the minute entry said something like, anybody who has at this point, having been warned, has not prosecuted their case. This case number is now dismissed. That's the way I recall it.
So you disagree that you're not covered by the subsequent dismissal?
I'm saying that, I have to take a look at that more closely, but if in fact the counterclaim was not dismissed because I was a holdout, and then the counterclaim continued to have life to it until it was dismissed for lack of prosecution, that is a legal pattern that could in fact be true. But I know that as a result of that stipulation, I did not stipulate to the counterclaim. And as a consequence, if I was a necessary party in that counterclaim, I didn't dismiss to the stipulation, then arguably the counterclaim was not ultimately dismissed until it was dismissed for lack of prosecution. Plaintiff is part of the STIP. I'll pass that, but it knew it. A big key element here is at the motion to dismiss level, I have to meet the motion to dismiss pleading standards. In this particular case, it's notice pleading. It's not specific fact pleading, and I think the complaint and the attendant materials indicate clearly that there was adequate support for the proposition that I had prevailed on the merits in the underlying claim. And I see that I'm out of time, and I guess that's it.
Counsel, we appreciate your argument. We'll take this matter under advisement and issue a decision in due course. We'll stand adjourned until the next argument. Thank you.